Hello and welcome. This is Andrea from SEM Parent Support Group, and I am here today to deliver the much anticipated training for tribunals. So without further ado, we will be looking at submitting the appeal, the legal test, the local authority response, extended appeals, evidence submission, the working document, the hearing and post-hearing. Now, as you will see, the second part of that slide focuses on our live training, where there would have been a Q&A at the end. So at any point, if this training does become live, you will have the opportunity to spend an hour questioning your situation and receiving answers to help you move forward. Please remember, if you have registered to join our training, either pre-recorded or live, please do go to the link in your email and get your CPD accreditation certificate. This has two purposes. Firstly, it tells us how many people are registering for the training, and it helps us continue with our CPD accreditation. So please do. Thank you. Okay, on the first slide, we're looking at the summary of what a tribunal process looks like. So it's broken down into four areas. You have, before submitting the appeal to consider, you have submitting the appeal, excuse me, and you have the legal framework and preparing for the hearing. And then obviously you have post-hearing, the time frame in which provision is done. So just briefly looking at before submitting the appeal. Mediation must be considered in law unless the appeal is solely about placement, and that is section I. Contact your mediator advisor within a 2-month time frame of your final EHCP decision notice. Time limits for appealing may be extended based on mediation certificate issuance. So basically, you have 2 months. If you appeal within that time frame, you then have an extended period of 30 days from mediation in which to then appeal. Legal aid eligibility should be checked for assistance with appeals if appropriate. Submitting your appeal. Appeal forms are available online. There is an electronic version and you can submit. It's about 67 pages long and predominantly is a tick box exercise with areas for putting in your reasons for your appeal. Supporting evidence can be submitted via email or post, but if you're doing it online, you can upload as you go. Anything you forget can be sent via a Send 7 form at a later stage, if beyond the evidence deadline. If within, then you would literally just email that to Send to Tribunal and CC the local authority legal team. The legal framework. The Children and Families Act 2014 and SEND Regulations 2014 govern the appeals process. The tribunal procedure outlines the rules and the powers for the tribunal. Preparing for the hearing. Get your ducks in order. LA must provide an indexed bundle of documents, understand the legal tests and evidence relevant to the case. Witnesses should be contacted in advance to ensure reliable connections. Now, the legal tests it's referring to are if you're appealing for refusal to issue, or if you're appealing for refusal to assess. So that's referring to the legal test A and the legal test B. A being may have SEN and B being may require special educational provision. Additionally, the law surrounding it that you need to consider is the Children and Families Act 2014, the tribunal procedures for health and education and social care chamber, the special educational needs and disabilities, so SEND regulations, and the Special Educational Needs and Disability Code of Practice 2015. Now, post-hearing is literally the time frame in which any orders would have to be delivered. So if it has been decided by the tribunal that an EHC needs assessment will be done, then there are specific timeframes for that, and we'll go into that a bit later. So, the next page. Before submitting an appeal, as we've discussed, mediation must be considered unless appeal is solely about placements. Contact mediation advisor within 2 months. Time limits for appealing may be extended based on mediation. Legal aid eligibility, again, should be checked if you need assistance with your appeals. Timescales. The average waiting time for tribunal is 12 months. Paper hearings often happen sooner. You are given that option when you submit your SENDIST appeal. Mediation is always an option unless it is for Section I alone. Often it can provide resolutions in full or in part. Either way, this is progress. And it's positive moving forward because it gives you less to fight over within the working document and deliver to the hearing. The LA have to arrange, by law, mediation within 30 days. You can choose to go straight to tribunal and get your mediation certificate. So in effect, passing go and collecting your certificate. You could submit your appeal up to 30 days after your mediation date, as I explained previously, because mediation, sometimes they do run behind, so it is always good to know. Submitting the appeal. We mentioned you can do this online. So effectively, what you're seeing in front of you here are 2 parts of the form. And again, referencing the law that is required in order to complete this. So the Send 35 form is the name of the form for submission. It can be downloaded via the tribunal website, or you can do it live online via the electronic submission, which is notably the preferred method. If not possible to do either of those, you can call the tribunal and the number is on screen, and you can send your appeal by post. The appeal form and submitting evidence can be also done by post. So, for example, when you come to the Send 35 and you're considering what to put in those areas, we have sampled one and it is pre-filled in a generic way. So on the left, you have your what are you appealing? And on the right, you have the reasons for the appeal. So the first one being, I am bringing the appeal because, and this has to be completed in all appeals, the final example, the final EHCP does not truly reflect all the needs of my child and is not fit for purpose. The second part, I disagree with the description of special educational needs, so section B, because. And then the third part, I disagree with the special educational provision, so that's section F. The LA have not considered, so in this example, a full speech, language and communication needs assessment, as was identified maybe by the UP or the OT, and they've not progressed that. Because in law, under the Children and Families Act, they are required to identify all SEN of a child brought to their attention. And in this process, you are bringing it to their attention via the EHCP. And so on. Okay. Now, appealing, what can you actually appeal? Well, you can appeal section B and F of the Educational Healthcare Plan. Section 37(2) of the Children and Families Act 2014, an EHC plan is a plan specifying, in brackets among other things, special educational needs and provision. Regulation 12 is when preparing an EHC plan, a local authority must set out the child or young person's SEN, which is section B. The special educational provision required by the child or young person, section F. And what should be included in sections B and F within the legal test, a child or young person has special educational difficulty or needs if he or she has a learning difficulty or a disability which calls for special educational provision to be made for him or her under section 20, subsection 1 of the Children and Families Act 2014. So that is the legal test. And then obviously you have your varying other tests there to refer back to. What can you appeal? Well, special educational provision means education or training provision that is additional to or different from that made generally for others of the same age. So any ordinarily available provision, otherwise known as OAP. So if your child is of school age, then this applies to mainstream schools in England, maintained nurseries, mainstream post-16, places in England at which relevant early years education is provided. Healthcare provision or social care provision which educates or trains a child or young person is to be treated as SEP, special educational provision, instead of healthcare provision or social care provision. Within EHCPs provision within EHCPs needs to be so specific and so clear to leave no room for doubt. Now, this part is the important part because this has gone to the government ombudsman, and as you can see, an example here from 1998 where it was deemed it has to be so specific and so clear as to leave no room for doubt as to what has been decided is necessary in the individual case. Very often, specification of hours per week will no doubt be necessary, and there will be a need for that to be done. Now, local authorities are wise to this, so they will slip a few in and miss a few out. So make sure when you are doing your working documents, for example, that you reference every medical report that you have. Okay, so the views of tribunal. The EHCP must give the LA a clear picture of what it is required to provide. That is key. Importance of flexibility to ensure the plan is smart and is practical for developing pupils' maximum individual potential. So it's always about developing the individual's potential, even if they're academically able, because their potential will be higher than maybe their peers. It is categorically not to be used as an excuse for lack of detail where it could reasonably be provided. And you can quote that. Degree of specificity within depends on the circumstances of each case, although the wholesale abandonment of detail is never permitted. I think we've all agreed that that does happen, and often that is the reason why we're at tribunal in the first place. Parents and young people will need to evidence not only what provision their child needs, but also that the level of detail sought within the EHC plan is necessary. Okay. Your application versus the local authority's response. So once you've submitted your application, the LA have a timeline in which to respond. So why are you bringing this appeal? You filled that in. I disagree with the description of SEN because I disagree with the specification of special educational provision because the LA have not considered. I disagree with the LA's choice of school because they have not considered X in section I. I prefer my choice of school, again, section I. The LA's response to your submission there is why it opposes the appeal, the name and profession of its representative, its address for sending documents to, so you would be CC'd in that response so that you have that information. That is a legal requirement. The summary of the facts about the local authority's decision, why they've come to that decision, and why the decision was made if this is not in the decision itself. Complex, but ultimately they have to quantify everything. The child's views are the reason why the local authority has not got them. So when preparing their response, the local authorities should consider the advice in the SEN Code of Practice. They should explain if and why they've departed from that advice. And that's part 3 of the Children and Families Act. So, Part 3 of the Children and Families Act and SEND Code of Practice is here in front of you. So the SEND Code of Practice 2015, provision must be detailed and specific and should normally be quantified. For example, in terms of type, hours and frequency of support and level of expertise. So what that might look like is that maybe your OT has put that your child requires a sensory diet to be implemented throughout the day. That actually needs to be more specific. For how long? Who's going to implement it? How do they access it? Etc., etc. Provision must be specified for each and every needs specified in section B. So in your working document or in your EHCP, section B should have all of your child's SEN. Section F should have provision to meet all of those special educational needs. There should be clarity as to how advice and information gathered has been formed in terms of the provision that's already specified, and where the local authority has departed from that advice. As we said earlier, they should give so and reasons. The plan should specify any appropriate facilities and equipment, staffing arrangements, and curriculum, any appropriate modifications to the application of the national curriculum. And that's the SEND Code of Practice, subsection 9.69. So the Children and Families Act, this is what they have to include in their response. Part 3 governs local authority obligations to children and young people in England with special educational need. In particular, Part 3, the law governs education healthcare plans. And the Children and Families Act is supplemented by the Special Educational Needs and Disability Regulations 2014, otherwise known as SEND Regs, which provide full details about the process local authorities must follow in relation to EHCPs. Now, you'll often wonder why, at this point, you don't then get to speak to your caseworker. Caseworkers do not have this level of knowledge, as we probably appreciate going through the process to amend a draft, for example. Ultimately, the legal team have full responsibility right through to the hearing. So you will lose your caseworker and focus on the SEND legal team of the local authority. So, extended appeals. When you are filling in your SEND 35 online or manually, it will ask you if you require the judge to make recommendations based on health and social care within your appeal, and that is known as an extended appeal. So in most appeals about educational healthcare plans, you can ask the SEND Tribunal to make a recommendation about it. It covers health needs, which go in section C, social care, which is section D, health provision, section G, social care provision, H1 and H2. In the instance of an extended appeal, you are actually asking the judge to make non-binding recommendations about health and social care. So bear that in mind. If you wish to make a section, an extended appeal, if your child has a children in need plan, for example, or requires further assistance under section 17 of the Children and Care Act, then I would definitely recommend you go for an extended appeal. After submission, what will you receive? So, upon submission of your appeal, the tribunal will send you confirmation that the appeal has been registered and the date of the final hearing. You will also have a case number, an ID, and you need to use that with everything that you are referring back to the SENDish Tribunal in any communication. Make sure that case ID number and the date of the hearing and your child's name are always in the subject heading of the email, for example. Case directions specify dates for which actions must be taken. So within your pack that you get from submitting your appeal, you will receive certain deadlines for you and for the LA to adhere to. You will also receive an attendance form and a case review form. Attendance form is for submitting who's going to be there and who your witnesses are. And a case review form generally happens about 6 to 8 months after your initial submission, and that really gives the tribunal an idea of where you are at that moment in time and if you are ready for tribunal. A copy is also sent to the LA, who are also issued with their directions. So some key dates for you to remember. The LA must send its response, all must send to each other, and the tribunal any final evidence. Case review, LA to submit bundle, final hearing date. Those are things you need to know in terms of dates. Tribunal attachments. You will have a case review form, you will have bundle guidance, and as you know, the tribunal has brought in new guidelines with regards to the number of pages, etc., and we have that available in group as a separate guidance. Working document guidance, again, we have that in group as a separate vlog, and that is specifically for working document. And useful forms that you need to know is Send 7, which is requesting changes, any changes you need, even support for yourself within the hearing, you would request that via Send 7. You would also need to ensure, if you were requesting changes, that you sent that to the local authority 15 days prior to sending it to the LA. You need their response, and by law, they have 15 days to come back to you with their response. If they reject change, then you can still send your Send 7 request to the tribunal, just with the local authority's response. And a Send 45 is the case review. Everything you must send to the tribunal must have your case ID on, just to reiterate. Working document. Now, although we're touching on this here, there is a vlog, and that's free, available to you in group. So a working document is a copy of the final educational healthcare plan on which both parties will work on to show the changes to the wording that they want or can agree, as well as those issues which the tribunal must decide on the day of the final hearing. Note, what has been agreed will not be discussed at tribunal. It is only outstanding issues that will be discussed at tribunal. So the tribunal key. Again, although it's visual there in the free vlog that we've got, and if you search in our group working document vlog, then details will come up specifically about that area. Who does what? Okay, once you submit your notice of appeal, the LA will turn the final EHCP into a working document, and that will always be in Word format. The LA then send it to the parents, who consider it and decide whether they agree with it. The parents can amend it to show the changes using the key below, and they are prepared to agree, and they use the key below and to highlight those which they are still not agreed on. So eventually, when you get to the hearing, that is what you're looking at. You're looking at areas that you have put in bold or the LA have put in italic, or that you've crossed out. So strike through effectively. If you can see my cursor, you will see that I am focusing on those areas now. But again, there's a separate vlog for that, and that is free. So eventually, once you have received it, your document commences as version 1 and then progresses to however many versions it takes. The working document can be worked on up until 10 days prior to the date of hearing. What can go in the working document? Any reports not referenced, you can add those. All medical reports and information that the LA choose not to include. Ensure that the correct info goes into the correct sections. So B, as a reminder, is SEN. F is SEP, so provision. CIN, Children in Need Plan, social care assessments, they can go in. Social care, G, D, C, H1, H2, and F. If it's educational. Personal budget relating to the section for care provision within the plan. So if you've gone down a social care needs assessment and you have a plan, then that would go into a personal budget. It could go into any one of those, G, D, C, H1 or H2, or F, again, if it's educational, but a budget for that would go separate, and that would be on the working document. And the working document must not exceed 25 pages. So as I've said earlier, Any evidence that you submit needs to be succinct and summarised without losing its impact or specificity. What happens next? At tribunal, no additional time is set aside for the parties to negotiate on the day of the hearing. The working document must be prepared and disputed before the date of the hearing, which is no later than 10 days prior. The sooner you start working on your version 1 working document, the sooner you can start progressing. If the LA are delayed in sending the working document, then let the tribunal know on email and CC the LA. Normally, the LA should start the process when it submits its response to the appeal and send it to the parents, a copy of the first working document and their response. However, we know that that doesn't always happen, so be sure to communicate with the Sendis tribunal and CC the LA in. Again, I can't repeat that enough. If they are not playing ball, they can impact that process because they would be effectively hindering the process within the regulations that are guided. The working document is sent to the tribunal in advance of the hearing so that they are aware of the detailed wording in dispute. Sometimes the options preferred by all the parties are brief and immediately clear to the reader. On other occasions, the issues are more complex and or lengthy, and the working document may be confusing unless the document is carefully drafted. You will often find local authorities, when submitting an EHCP, do not put the information or leave the boxes in the right place. So section B sometimes is top heavy. Sorry, section A is top heavy, so section B is just one line within the particular core area of need, for example, cognition and learning. And then they do not put the special educational provision and who will do what in a format that flows. So you will often find, I suppose what I'm saying is that when the working document comes to you, it will be slightly different. And they do this to keep the tribunal happy. They should do this from the outset, but this is just one of the tricks in my experience that I have found. Okay. Again, footnotes are not allowed, but if you're putting evidence in F and evidence in B and it comes from a specific document, which it always should, then you could put EP report page 12 and there's your evidence. And that saves massive amounts of time at tribunal, because otherwise what you will find is people shuffling through their bundle, which is generally quite a beast. Do not send every version of the working document to tribunal. They do not need that. They only need to know if an additional party is not playing ball and you are having difficulties, or if you're sending additional evidence for consideration, like a late OT report, for example. The tribunal only needs the last copy of the working document. The tribunal will only focus again on what is remaining to be agreed upon. So don't walk into the tribunal, and that's hypothetical because predominantly they're online. Don't enter it thinking this is going to be confusing, I'm going to lose my focus. You are focusing purely on what has not been agreed. Okay. So again, the Judiciary Code of Practice for hearings after July 2025. These are the additional areas that you need to be aware of when dealing with evidence in terms of the working document and the page limits in terms of bundle. So what must be included is the parent and young person's notice of appeal form and reason for appeal or amended grounds of appeal. And generally the bundle is provided by the local authority, but you need to check that they've not missed anything out. You need the LA decision letter, the LA response to the appeal, and any supplementary or amended responses. Any requests for change made with other sides' views. All tribunal orders, any further written submission made by the party by order of the tribunal. So any Send 7s, any evidence, and the case review form. Part 2 of the EHC plan which is a 150-page limit applies to this. If relevant to the appeal, a copy of the EHC plan under appeal, all appendices listed in section K. So if you have 5 or 6 medical reports you are referencing, then be aware of that page total, and it is 150 of those combined. The working document must not exceed 25 pages of A4 in itself. So in essence, you've got 275 pages maximum, and you'll be surprised how much is collated. A case review is about 8 pages, and that's if you've not added any additional information. So there you go. Any bundle that fails to comply with the provision of the practice direction on the maximum number of pages included in the bundle could be rejected unless there is an accompanying note explaining why non-compliance is essential. Okay, so the hearing itself. In terms of the environment, what you're walking into is an online environment, very similar to this, except you will have the judge, 2 laymen, which are specialists in SEND education and education law. You will have the local authority, you will have yourself, you will have your witnesses, they will have theirs. So there could be up to 10 people on screen, depending on the amount. And just on that, if you have a witness that can't attend, because most tribunals happen morning, if, for example, you have a witness that couldn't attend, it could be that they would be required to attend at a specific time in order to make sure people are not wasting their time. So when their part is relevant to play, and that's generally guided by the judge. So order of works, intros. Okay, meet and greets, who you are, and then you'll get straight into the working document to review what is left to negotiate. All parties will be in possession of the bundle. The LA's responsibility is to ensure that you have a copy of the final bundle. The judge will have understood what you have agreed thus far and what remains. The working document is gone through page by page. Now, if you need any reasonable adjustments during that, then you can send a Send 7 during your time frame in order to request. I mean, you could request that you have an interpreter. You could request that you have a time element to process any information that is being given in order for you to make a decision. You know, whatever you need. So you are the expert on your child. Don't be afraid to question witnesses. So if the LA bring a witness, that witness is also your witness. And if they're bringing somebody to quote or to try and discredit any of your potentially private reports, then the fact that they haven't met your child is a big plus. And it is always worth spelling that out and using that as an opportunity to question. How do they know? What have they seen? How can they, in their professional frame, question this report when this report has been delivered on the basis of 4 or 5 hours spent with the child? Okay, so top tips. Composure. And I know it's really hard because you're in a situation whereby you feel intimidated, I think, and scared. You'd be human if you didn't. So please do try and take that as a comforter, because the judge is aware that you haven't got any legal representation and that the LA are doing all they can and spending the taxpayers' money to fight this. So bear that in mind. So composure needs to be calm. Opening statement, prepare one. Prepare a statement that has no more than a couple of paragraphs. And I had picture on my child on my desk. And when I was referring to him as he was and how he is now, that was 2 very different pictures, but it was impactful. It's always worth doing that. So prepare a statement, no more than a couple of paragraphs, and have a picture of your child and in view of the camera. On task, refrain from going off on a tangent and remain on topic at all times. Be concise in your communication, because if you're not, the judge will bring it back anyway. So the best thing you can do is prepare. So remember, you're there to discuss what has not already been agreed. Work through the bundle. The working document gets worked through page by page, and in your bundle I would recommend using in terms of keeping card notes or pointers, or using those, you know, illuminous post-it notes, the thin ones, so that you can go to every section. Anything that would help you stay in focus with what is happening within the tribunal, the hearing itself. So organize the bundle, use coloured tabs to help you access the page that you need to at any given point, so you're not losing time. And witnesses, as I've said, LA witnesses are your witnesses too, and they haven't met the child. The judge knows that. So remember, the objective is to find solutions for outstanding issues. Now, the timeline post-hearing, the EHC refusal to assess. If the judge orders it, then they have 2 weeks in which to commence, 10 weeks to notify if they're not going to issue, and 14 weeks to complete the plan. In refusal to issues, the LA have 5 weeks to issue. Appealing contents, the LA must amend within 5 weeks. Appealing settings, the LA must amend in 2 weeks. And appealing a cease to maintain, it's upheld immediately. So the LA must amend 5 weeks. All other areas brought to appeal whereby the LA have been advised to reconsider their decision, that is 2 weeks. In terms of appealing a send tribunal decision, and they've got 28 days to submit. So, all very complex, and we've gone through 18 pages there, and you know, that doesn't cover everything and all the questions that you have. So if you have a question after this presentation, then scroll back. If it's not answered, please use the group's platform and ask your question. We would be happy to answer any that you have, because this isn't live and you don't get that opportunity. So hopefully that has helped. Please do go get your CPD certificate. These are professional points and professional accreditations that you receive throughout any of our training. And what that means is our training has been verified independently in terms of the laws, the points of reference, and the quality and how we deliver. So get your CPD points, and there is a working document free vlog in group if you search our vlogs under media. Thank you.